to the third case on today's docket, Matthews versus the state of Florida.
Good morning. May it please the court and counsel, my name is Jalissa Fontan, and I, along with my co-counsel, Ms. Chelsea Shirley, represent Mr. Douglas Matthews. Mr. Matthews is before this court on an appeal from a 3851 with claims of ineffective assistance of counsel and newly discovered evidence, namely with respect to the fingerprints that were discovered in post-conviction in the contents of the victim's wallet that do not belong to Mr. Matthews, but specifically actually belong to the state's star witness in the case, Mr. Justin Wagner. Further, trial counsel was ineffective and prejudiced Mr. Matthews by failing to investigate the evidence in this case and consult with forensic experts to present evidence that supported Mr. Matthews' theory of self-defense at trial. The reason that these fingerprints are so vitally important...
Do we have many self-defense cases in our law that involve 24 stab wounds?
Your Honor, it is possible that there are cases of that. I cannot name that at this time. However, specifically, the fingerprints in this case are vitally important because the state argued that the whole premeditation and the felony murder aspects of this case rested upon the theft of the victim's wallet in this matter. And they actually argued it to the jury. However, there are no fingerprints of Mr. Matthews on this wallet or on the contents of this wallet. However, the fingerprints of Justin Wagner, the alleged only witness in this case as to what actually occurred, his fingerprints are within the contents of the wallet, specifically his middle and ring finger. And it appears that from where they are placed in the contents of the wallet, it was a Post-it note that was in the wallet, that it had to be from going through the wallet, pulling out contents as he went through it. To give you a brief background on this case, Mr. Matthews has always contended that what happened in this case was self-defense, that he did not kill Ms. Trujillo, that was Mr. Zoeller's act, but also that Mr. Zoeller confronted him and attacked him, and the attack ensued from there, and that he acted in solely self-defense. The finding of the prints completely undermines the state's theory of that Mr. Matthews premeditated this crime and murdered Mr. Zoeller and Ms. Trujillo because they cannot prove the theft of the wallet was by Mr. Matthews. To further this, the wallet was actually found after the crime in a Dr. Seuss bag that actually had contents that belonged to Mr. Wagner, specifically correspondence from his girlfriend addressed to Mr. Wagner. This bag was not tied to Mr. Matthews. It was actually also discovered in a common area of another witness's house, Ms. Teague, that Mr. Wagner actually told the police he had entered and left several times after the crime. Further, counsel was ineffective because they did not actually truly investigate the evidence in this crime. The only time they went to investigate the evidence was apparently to get some phone numbers that Mr. Matthews claimed that he needed. They never even considered whether to use forensic experts in this case, and I believe that the use of forensic experts in this case would have supported Mr. Matthews's claims of self-defense and supported them. Specifically, they failed to get a crime scene expert to examine the crime scene evidence, the evidence from the crime, as well as to actually review the crime scene. The evidence from the crime scene, specifically the photographs from the crime scene, reveal that where Ms. Trujillo died, there is no evidence of the struggle that Mr. Wagner claims that he overheard in the room. Mr. Wagner testified specifically at trial that he heard some noises in Ms. Trujillo's bedroom, and that only after that Mr. Zoeller zoomed out with Mr. Matthews following him in pursuit and stabbing him. However, the crime scene evidence does not reveal any signs of a struggle that would account for the noises that Mr. Wagner testified to at trial. Further, the crime scene photos reveal as well that there is blood spatter throughout the kitchen area where Mr. Matthews says that Mr. Zoeller confronted him. And it actually supports that there was a struggle, not just running through the house, but an actual struggle that occurred. Further,
There was no evidence of any injury on Mr. Matthews at all, correct?
there were a couple of small scratches. Trial counsel also did not obtain an expert to try and explain how those scratches may have been from the attack. They tried to rely on the detectives who had no expertise in that and admitted that they did not.
I'm still struggling to understand how the fingerprint on the note in the wallet in any way is even particularly relevant to the self-defense claim.
It is relevant because the state at trial specifically said that this was all motivated by theft, specifically the theft of this wallet. And the state made a very big deal out of it in their closing arguments that the whole motive was this wallet, this wallet. This is why these people died. And I'm paraphrasing a little bit the state's argument, but they were very focused that this wallet is the reason that this crime happened.
So Mr. Matthews admitted the killing.
He admitted to having a fight with Mr. Zoeller.
No, he admitted
To killing Mr. Zoeller
Yeah.
only. Yes.
Right, okay. And then he, and the mode of killing does seem logically inconsistent with self-defense, and the crime scene evidence doesn't. I mean, I'm still struggling to see, I'm sorry.
I understand. And the crime scene evidence does actually demonstrate that a struggle had to have occurred in that house, and it did not happen the way Mr. Wagner said. Mr. Wagner says that Mr. Zoeller simply was running out and the stabbing was occurring as they were running. However, that's not actually the case. There's actual evidence of blood spatter throughout the kitchen that reaches the walls opposite the kitchen all over the place, which would indicate that the person, they were in a physical struggle and there were slashes and not everything else. Also, what would have been useful is had counsel actually used a medical examiner as well to look at the wounds that Mr. Zoeller suffered, because Mr. Zoeller, it wasn't just consistent stab wounds as you would think. Mr. Zoeller had slash wounds, had other wounds that were consistent with if two people are struggling over a knife and going at each other. I know that...
Was the blade broken off in his skull, in the victim's skull?
A small portion of the tip, sir. But even though that this crime may appear to have occurred in a frenzy, it does not discount that it started as a case of self-defense. Obviously, during penalty phase, which we are not discussing here because that is not part of this appeal, there would have been evidence to point out Mr. Matthews' mental state, how it affected his actions during the crime, if, you know, when it got to a penalty phase.
Can I talk to you about that for a moment?
Absolutely.
The fact that we're not here on discussing any sort of penalty phase issues.
Correct.
And I want to ask about jurisdiction, if you don't mind.
Sure.
For the questions I'm about to ask you, put aside all of our prior precedent. Don't assume it existed up until today's date, okay?
Yes, sir.
The Constitution, as I read it, and I'm reading from Article 5, Section 3, subsection B1, states that we shall hear appeals from final judgments of trial courts imposing the death penalty. So first of all, is the order that we have a final judgment?
It is.
How is that a final judgment?
It is a final order from a proceeding after a motion 3.8.
It's an order, but it's not a judgment, is it?
We're not here on the judgment per se, because we're here on the final
Right.
denial of a 3851, which is a direct appeal to this court.
Well, again, put aside all prior precedent. I know that's certainly what we have said in the past. I'm merely asking these questions. So, okay, let's put aside the judgment order issue. Is it an order, let's even call it an order, of the trial court imposing the death penalty? Did this order impose the death penalty?
It did not.
All right. And then let's assume for the moment that we rewind to 1988, where there is precedent which says that for post-conviction orders, we do review those. Here, is there currently a judgment that imposes the death penalty?
Mr. Matthews, his death sentence currently
Was vacated, right?
was vacated.
Right. So there's no current judgment at all anywhere in the history of this case right now that exists imposing the death penalty.
There is still a conviction for first-degree murder.
Absolutely. And normally convictions for first-degree murder without imposing the death penalty are appealed to where?
To the DCAs.
Right.
Under normal circumstances. However, because this began as a death case and the state still will be seeking death on Mr. Matthews, it's still a death case.
Does that, let's assume that isn't a jurisdictional defect, does that maybe tell us that we should wait to see before deciding? In other words, let's see what happens if, for instance, the jury comes back 11-1. I won't say which way, but 11-1. Doesn't that mean that the case no longer is a quote-unquote death case or capital case, and therefore it should go to the DCA? Should we just wait to see what happens?
I don't think in this situation we should wait to review his guilt-phase claims because they're still valid guilt-phase claims. And if we have the opportunity to resolve them at this point before it goes back to a tri-court, it is simply much more judicially economical to do so at this point rather than have it hanging out there, go through the entire proceedings again, and then bring up the old guilt-phase issues from his very first trial.
Haven't we said, though, that piecemeal litigation is itself inefficient? In other words, if we look at inefficiency, isn't piecemeal litigation, which this would be, let's assume this jury does come back and impose the death penalty, we then would have to litigate any claims that happen with there after having already litigated in the same post-conviction setting the guilt phase claims, right?
In post-conviction, obviously, piecemeal litigation is frowned upon, but I don't believe that in this particular situation it is piecemeal litigation because we're bringing the final results of the post-conviction to this court in order to be resolved before it goes back to a trial court brand new.
Well, let me ask you this. Well, my last question, and I'll let you get back to what you were talking about, but only because you brought up what happened at with the sentence. Putting all of our precedent aside, would you agree that reading it cold and with the questions that I answered that we don't have jurisdiction in this case? Again, putting all precedent aside.
I would still disagree, sir.
Why? Tell me your best reading as to why the fact situation that we're in right now would fit within what the Constitution allows and requires.
My best reading of this, sir, is that, although Mr. Matthews' death sentence is currently vacated, Mr. Matthews is still on death row, still suffering the consequences of that judgment, even though it has been vacated. He has not been moved. He is still under that sentence as far as everybody is concerned at this moment until the circuit court re-reviews this.
So because DOC classifies him some way, that gives us the jurisdiction?
And also because the state is still seeking death on my client.
Okay, thank you.
And if I may have a moment. Now, going back to the ineffective assistance of counsel on this case, counsel was still further ineffective for they did not question Mr. Wagner on a variety of points that they could have been able to question him had they actually really truly reviewed the evidence on this case, and not just the fingerprints, which are newly discovered evidence in this case, but also evidence that was already available to them. Specifically, Mr. Wagner gave 2 videotaped statements to the police. In those videotaped statements, Mr. Wagner lied a lot to the police, but more specifically, in his second videotaped interview with the police, which is post-exhibit number 66, Mr. Wagner was asked by the police, you need to be either a witness or you're going to be a defendant kind of conversation. And, why don't you just say that this was a robbery gone wrong? And Mr. Wagner told the police at that point that he would say that, and to quote, "To save my ass, I will." He would basically say whatever the police told him. And Mr. Wagner actually reiterated this in post-conviction, that he was drug sick. He wanted to get back out and get back on drugs. He did not want to be locked up. He did not want to be blamed for this either. And he was like, I would say anything they wanted at that point. And he actually did testify to this in post-conviction. And this is a wealth of information that would have been useful at trial if you're presenting to a jury that your client acted in self-defense, and the only witness you have is a liar, is a complete drug-addicted liar who lied consistently to the police and was probably still lying at the point of trial. This evidence was really important, and this was something that trial counsel simply did not do and did not confront Mr. Wagner with this. Further, because they failed to investigate and did not find these fingerprints, they failed to confront Mr. Wagner with the fact that these prints actually have, these prints are inside the wallet, clearly in a position where it looks like so he was the one who went through the wallet. And notably, the wallet is without money when it is discovered, and no money is discovered on Mr. Matthews at the time of arrest, which goes to show that trial counsel in their errors did undermine completely and prejudice Mr. Matthews at trial by not presenting all this evidence that supports rather than detracts from a self-defense case. Mr. Matthews has always consistently held that.
On the ineffective assistance claim related to that fingerprint, given the high standard, I mean, the counsel's testimony was that my client told me that he committed the crime and didn't say that this witness was involved in any way. So I didn't see any point in conducting that level of investigation into fingerprints on the contents of the wallet in light of what my client told me. How is that unreasonable?
It's unreasonable in particular in this case when the state is arguing for the purposes of premeditation and felony murder that the whole motivation is theft, that in actuality this is some sort of theft gone wrong in the context of a drug deal. The defense really, especially when death is on the table, needs to actually investigate and try to combat those claims, combat claims of theft. If my client is telling me, I didn't take that wallet, I acted in self-defense, I would try as much as I can to demonstrate to a jury that that wallet has nothing to do with my client, and that was taken as an opportunistic thing by the witness. Obviously, during the combat, Mr. Matthews is not going to know where that wallet went. In fact, had no idea that that wallet was even in the Dr. Seuss bag because police actually questioned him on that. And he has never been able to say, I don't know how I got there. Whereas Mr. Wagner, who has lied consistently, won't even admit that he touched the wallet, although it's sitting in a bag with correspondence addressed to him. And I think that's vitally important. And at this time, I'm going to reserve my last 3 minutes for rebuttal. Thank you.
May it please the court. Lisa Marie Lerner for the state. Addressing the newly discovered evidence claim, the court needs to focus on the two prongs. The trial court found that the defense met the first prong, that it was newly discovered and they would not have discovered it with due diligence. The state may disagree with that, but we will take the trial court's ruling as it is. However, the second portion of the newly discovered evidence claim is it would likely produce an acquittal at trial, and there is no way the defense can meet that burden. Mr. Matthews admitted to killing Mr. Zoeller. An acquittal does not mean a conviction for a lesser, or as the defense puts in their briefs, a possible life sentence. That is not the standard for newly discovered evidence, and the defense cannot meet that burden. Additionally, the trial court fully analyzed this and noted that Mr. Matthews admitted to killing Mr. Zoeller. Mr. Matthews had no defensive wounds on him. My counsel said that he has scratches. The testimony at trial was that he had no scratches. There was no broken skin. The police officer testified that he had a slight red mark, similar to a red mark a person would get if they were laying on a pillow and the pillow was creased. The police officers took photographs of his hands, which were admitted to the jury. He had no scratches and no marks on his hands, which completely belied a self-defense claim. If there was a struggle over a knife and Mr. Zoeller was wielding this knife, trying to attack Mr. Matthews, Mr. Matthews would have had defensive wounds either on his hands or his forearms. He did not. However, Mr. Zoeller did have defensive wounds on his forearms. What Mr. Wagner testified at trial was that Mr. Matthews and Donna Trujillo went back into her bedroom and were back there for approximately 15 to 20 minutes before Mr. Zoeller was called back in there. Mr. Zoeller was there for a few moments before, as he put it, Mr. Wagner put it, everyone started freaking out, and he heard a bang and then screaming. Immediately on that, Mr. Zoeller came out of the bedroom with Mr. Matthews essentially on his back. Mr. Matthews was stabbing him in the back and the head. Mr. Zoeller had 24 stab wounds, including a wound to his face up by the eye area that went through and cut the veins and arteries in his neck. Mr. Wagner testified that when Mr. Zoeller came out, Mr. Matthews was stabbing him, and Mr. Zoeller tripped. This was a very small apartment, and the kitchen and the living room were essentially one area. It was very small, and the kitchen led into the bedroom. Mr. Zoeller tripped and fell in the area between the kitchen and the living room, almost on Mr. Wagner, who was sitting on the futon. Given the neck injuries and the gushing of the blood, that would explain the blood spatter in the kitchen and the living room area. Mr. Wagner testified at that point he took off. And he also testified that when he looked behind him, Mr. Zoeller had attempted to get to the door, but Mr. Matthews was pulling him back and stabbing him. All of that is evidence of premeditation. And even if this fingerprint had discovered, it would not negate the stab wounds and the fact that Mr. Matthews was attempting to get Mr. Zoeller back toward him so he could continue to stab him, rather than letting Mr. Zoeller leave if it was a true self-defense.
Let me ask you about jurisdiction. You do argue in your answer brief that the court does not have jurisdiction to hear this case, correct?
That's correct, and it's the state's position that this court should not be entertaining cases in this posture, and we've argued that previously in other cases.
Consistently. And your argument is that because the judgment entering a death sentence has been vacated, we do not have jurisdiction to hear the post-conviction matters. Is that your argument?
Yes, that's correct. It's the state's position that it would probably be a better procedure to go ahead and to do the penalty phase trial and then do the post-conviction after the new penalty phase trial, whether it be a life sentence or a death sentence at that point, in order to keep all the post-conviction claims together.
Okay, so your position is we should essentially hold this in abeyance until after?
Yes.
Okay, so it's not your position that the language in the Constitution does not allow us to hear post-conviction claims in a normal death penalty case where the judgment entering the death penalty is intact?
No, it is. They're two different things.
Right, I understand.
One, this case could go to post-conviction in the fourth DCA and do it that way, but it would be, in our opinion, it would be a cleaner post-conviction matter if it were held in abeyance and wait for the retrial on the penalty phase. But it is the state's position that cases in this posture should not be entertained by this court until there is a judgment for death.
There was DNA evidence, was there not?
Yes, there was DNA evidence found on Mr. Matthews' body and, in addition, on his clothes. There was DNA evidence found on the T-shirt, which was found in this plastic bag in Ms. Teague's apartment. It was on a shelf in the living room right next to the bedroom where Mr. Matthews was hidden. The DNA was also found on his jeans, next to the bed, and on his sneakers. The DNA on the clothing belonged to Mr. Zoeller. However, there was also DNA found on Mr. Matthews under his nails. There was evidence that Mr. Matthews had tried to clean up when he entered Ms. Teague's apartment and had washed in the shower. However, Mr. Zoeller's DNA and blood, DNA from his blood was found under the fingernails. And interestingly enough, Ms. Trujillo's DNA was also found under Mr. Matthews' fingernails on his left ring finger. It was a mixture, but her DNA was found there, and I believe the exclusion rate was 1 in 26,000. So Mr. Matthews had DNA from both victims on him, and the jury heard that. And they also heard the rest of this evidence when they rejected the self-defense claim. In terms of the IAC, in terms of the fingerprints, the trial court found no deficient performance, but however, in its order, even though he didn't mention it, the trial court did a prejudice analysis and found essentially that Mr. Matthews could not meet the prejudice prong of the ineffectiveness. The trial court found that the fingerprint had little evidentiary value given the fact that Mr. Matthews admitted to killing Mr. Zoeller. The wallet was found in his possession. The wallet was found in this plastic bag under his shirt with the victim's blood on it. And Mr. Wagner provided a hypothetical possibility at the post-conviction of how his how his fingerprint got on this Post-it note. He said that he was friends with Mr. Zoeller, drug dealing friends, and that they had gotten together previously on a number of occasions to divvy up drugs and to cut up cocaine, and he had to scoop it up. When you scoop up cocaine or other powdered drugs, you had to use a piece of paper or a card or something, otherwise it would dissolve on your fingers. And that was his explanation of how his fingerprint could have gotten on this Post-it note. The fact that the fingerprint was on the Post-it note is not evidence of rifling through the wallet. The wallet contained 10 different items, and the fingerprint experts indicated that there were fingerprints all through the wallet. However, they were not identifiable. This was the only identifiable print. So there were prints in there other than Mr. Wagner's, it's just that they were not identifiable. In terms of the crime scene expert, while the trial court summarily denied this, there was testimony at the evidentiary hearing, and therefore the trial court's denial of this and his written order was also informed by the testimony at the evidentiary hearing. Both counsel, the state and the defense, questioned Mr. Nielsen as to whether or not he considered hiring forensic experts. And Mr. Nielsen testified that he reviewed the evidence at the sheriff's station. He made an appointment with the detectives and went through all the evidence. But given the fact that he was stuck with a self-defense defense, since Mr. Matthews had given a statement to the effect to the police and it was tape recorded, and also that is what he told Mr. Nielsen, that was going to be the defense at trial. And Mr. Nielsen testified that the evidence, the physical evidence of the struggle in the house, the blood on the shirt, and everything else was consistent with the self-defense. So he considered hiring forensic experts, but decided not to do so. He did not have a specific memory of considering a fingerprint expert, but he did, as he did in all cases, consider forensic experts, whether or not they would be helpful. But as I said, he had a self-defense issue. None of the physical evidence contradicted that, and so he decided not to hire self-defense. In terms of ineffective assistance of counsel of interviewing the witnesses, again, while the trial court summarily denied this, there was testimony at the evidentiary hearing by both Mr. Nielsen and Mr. Dowdy about their preparation and cross-examination of Mr. Wagner. They testified that they did go through, and the record reflects this, and the trial court mentions or details this in its order. They did go through and impeach him by his prior convictions, by the fact that he lied to the police on a number of occasions. And Mr. Wagner, both during his statement and then at the evidentiary hearing, testified that he did not say he would say anything that they wanted. In fact, the tape of Mr. Wagner has him saying, I'll say that if it will get my ass out of trouble. And the detective then says, we don't want you to say it, we want you to tell the truth. That is on the tape. And at the post-conviction hearing, when Mr. Wagner testified, he said, I wasn't saying I was going to lie. I said I would tell them everything that happened. And what I said was the truth, and what I testified was to the truth. So counsel's insinuation that Mr. Wagner would lie in order to get himself out of trouble was not accurate. Mr. Wagner also testified at trial that the state and the police did not assist him in any pending case. He was questioned on a case he was going to court for at the time. In terms of his statement at trial was consistent with his statement to the police, which was videotaped. And he had no pending charges when he gave the statement to the police, which was consistent with his trial testimony. The defense in its brief mentions the fact that he was arrested for a domestic battery charge. However, no, he was not arrested on that, and no charges were filed at the time he testified. Charges were later filed after the trial. So it was not a situation where the state was giving him any benefit because no charges had been filed at the time. And Mr. Wagner testified at the evidentiary hearing that he never received any help on any cases from the state. He did his time, he was charged, and he went to prison. And if the court has no further questions, we ask this court to affirm the denial of post-conviction relief.
To address some of the state's arguments on rebuttal, there's a lot to unpack there. First off, the state alleges that we cannot meet the burden for newly discovered evidence. For newly discovered evidence, the standard is that obviously the evidence is newly discovered and has the probability of resulting in a different outcome in this case. I believe that the newly discovered evidence would assist in potentially giving a different outcome in this case. There are issues in this case, and the jury did clearly have issues in this case with Mr. Wagner's testimony with respect to actually the death of Ms. Trujillo. Mr. Matthews was originally charged with first-degree murder, both premeditated and felony murder as well, for the death of Ms. Trujillo. However, the jury there found manslaughter instead, which shows that they at least took some of Mr.
The argument actually, and I'm quoting from Duggar from this court, the newly discovered evidence must be of such nature that it would probably produce an acquittal on retrial, which is different than the language you used. You said a different outcome. And you want, maybe you could address how this would result in an acquittal.
Yes.
Or is that the wrong standard? Are you arguing that that's an incorrect standard?
No, and in some cases, it says to result in an acquittal, and there are cases that say it would result in a probability of a different outcome, which is a little strange, but the most recent case law to state, as you were quoting, that it would result in acquittal. And I believe it would result in an acquittal because the premeditation and the felony murder aspects of this case, especially with respect to Mr. Zoeller, is the linchpin is that they're claiming that the whole thing is motivated by a theft. And if you can eliminate that motive entirely in the mind of a jury, then you're left with, well, what's left? You know, and also it goes...
What's left? 24 stab wounds. Testimony that he's dragging him back in there when he's trying to get away.
There's also alternating testimony that that is not what occurred, even though there are 24 stab wounds, that this was done in self-defense. Furthermore, if counsel had actually done their job appropriately, they would have been able to demonstrate that this dragging back didn't actually occur because the blood evidence does not match up to that. The blood evidence actually demonstrates that there is no dragging back, that most of it is actually in the kitchen area, which is towards the back of this very tiny apartment. There's actually no blood to where the futon is. If you actually look very carefully at the crime scene evidence, Mr. Wagner testified at trial that when Mr. Zoeller tripped, he practically landed on his lap, but there's no blood evidence to show that in that position where Mr. Wagner claims this occurred. And they wasn't cross-examined on it. It wasn't properly argued in front of a jury. And this is the whole thing with newly discovered evidence.
You're now in overtime. I'll give you about a minute to sum up.
To sum up, when you actually examine this the way you have to as a cumulative, both everything that was in trial and everything that was discovered in post-conviction, this would result in an acquittal. And I believe that we meet not only the newly discovered evidence, but we've also met our burden for ineffective assistance of counsel. Thank you.
All right. Well, we thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All rise.